Hi, Clara. Hi, Alejandra. Um,
Hello,
I
everyone.
I saw them last in, was it in Geneva?
Okay.
Yeah, when I raised some of the questions that Luke said he would be afraid if I raised them again today, in relation to the Belfast guidelines. As I said earlier, I'm not a fan of norms, and guidelines come very close to arguing that there's a norm for these uh, things. But the value of the guidelines, of the Belfast guidelines, is that, and I'm going to be sweeping before I ask the three of you to talk about it. The value of the guidelines is in the fact that it comes from field work. The value of the guidelines is that it comes from field work that was done mostly in the global south and even in Northern Ireland, where, like I said, apologize for the sweeping statement here, where you have third world problems in a first world setting. And you know, that's probably the least harmful thing to say about Northern Ireland. um, and so the value of the Belfast Guidelines is that it emerges from contexts that matter today. Um, it becomes more valuable when we remember the United Nations 2005 UN General Assembly Basic Guidelines on Reparations. We've used that for many, many years, including in our work in ICTJ. It's helpful because when Nepali politicians ask, is there international law about reparations? Then we say there are basic guidelines. We don't tell them that it's not a treaty. We don't tell them that it's, you know, just a document that you can Google online. On the other hand, you have scholars from Queen's University or Ulster who will then point out it's soft law. Nobody really respects it and then says, you know, there are norms, in other words, and these are not normative yet, or at least some of them are not. But there was value to the UN Basic Guidelines to some extent because of that. But the UN Basic Guidelines emerged in 2005, but emerged from negotiations that I think were parallel to the negotiations on the Rome Treaty, the ICC Treaty, and some of the same people were involved. And so the premises were sometimes overlapping, that impunity was important to counter, but impunity really talks about prosecutions and individual perpetrators and less about what victims need or what victims want. The 2005 guidelines were also adopted by consensus, and you know what consensus brings. It brings a lack of clarity around exactly what they mean. On the other hand, we do have to acknowledge that the basic guidelines were driven by some global South experiences, Chile in particular. At that point, Chile had released its second Truth Commission report, the VALEC report, which was about torture and survivors of torture. So people who were alive who could express what they needed as torture victims. Unlike the earlier Truth Commission of Chile, which was focused on dead people or disappeared people who could not talk anymore, but whose families were still there. So based on that experience, and if I remember correctly, this was also the first time, of course, that international humanitarian law was linked very explicitly to reparations, so IHL. And this was precisely, I think, why the United States was the only country that I can remember who raised a question about that, whether IHL and reparations should intersect. But it was by consensus, so perhaps the US ambassador to the United Nations just gave in and said, let's go with it, because anyway, it's soft law. Of course, the Belfast Guidelines are even softer. And so perhaps this is now the time to discuss what can be done to make the ideas here adaptable. And some of the work that we are doing in ICTJ is precisely that. I was just telling some of you here that we brought in, when Colombia was negotiating the peace agreement, of course there were advisors from the IRA talking to the FARC. And it was important, I think, that that exchange was happening. But then we were also working in Nepal, and Nepali politicians were looking at what was happening in Colombia and wanted to adopt what they claim was the leniency of Colombia in relation to FARC guerrillas, because they wanted that leniency for themselves. So we brought in Colombian peace negotiators to Kathmandu to talk to Nepali politicians. So you can see here the value of global South exchanges, the value of people interacting with their experiences and exchanging the knowledge, and that's the value of the Belfast Guidelines. It's an exchange of knowledge consolidated into a little green book, not by Gaddafi, but sorry. But that's the value of the Belfast Guidelines. It distills these global South experiences. So I'd ask Alejandra first to tell us about the guidelines, and then Clara and Luke.
Thanks so much, Ruben. It's really lovely to see you again, and also to see Luke and other colleagues. It's really a pleasure to participate in this event. And I want to start first by explaining why, what's the reason behind us developing these guidelines, what was the objective, and in part you already answered that first question of why in your introduction, Ruben. But as you said, the UN Basic Principles were adopted in 2005, and that's more than 15 years ago. At the time of the adoption of the principles, and Redress is one of the organizations that was involved in the drafting and advocacy around the principles, as well as the Rome Statute of the ICC. But at the time, the adoption of the principles was a huge, huge success for the victims movement all around the world. As you very well said, it was the first time that really the right was explicitly recognized in relation to human rights violations and also humanitarian law violations. But of course, since 2005, a lot has happened, and a very important body of practice has developed. And if we think about it, it was only in 2005 as well that a reparations program was adopted in Peru, following the recommendations of the Peruvian Truth and Reconciliation Commission. Equally, in Guatemala, the reparations program was set up in 2003, but it took many years to take off the ground, and the implementation is still ongoing today. In fact, in 2013, the program was renewed for an additional 10 years, so it's still ongoing. In Nepal, you referred to Nepal. In Nepal, Ruben, a reparations program was proposed in 2006, but little progress has been made since that. And then on the ICC side, since the Rome Statute was adopted, it gave us for the first time the opportunity to have an international court mandated with the prosecution of the most responsible individuals for mass atrocities, with a mandate to ensure that those convicted would provide reparations for the victims of those crimes. We all know that the realization of that reparations mandate of the ICC has been a path with many obstacles, and that it was only in 2012 that the ICC chamber developed principles around reparations called the Lubanga Principles. And it was also in the Lubanga case where we got the first reparations ordered in 2012 as well. So we can see that from 2005, when the principles were adopted, a lot has happened. And from this very rich experience that we have accumulated, we have learned many lessons as well. And in part, this is reflected in the research that has been conducted and published under this project. In particular, we have seen some common challenges and obstacles that victims face, and some limitations in the implementation of the basic principles. One of the main challenges, in my view, is the lack of proper implementation of the basic principles. For example, according to the research that has been conducted by Queen's University during the project, in Guatemala, only 32,800 victims have received compensation. And this is out of a total number of 200,000 dead and disappeared, and 1.5 victims who were displaced. In Uganda, for example, the peace agreement was achieved between 2006 and 2008, but the National Transitional Justice Policy was only adopted by the government of Uganda in 2019. And even though it includes the obligation or the purpose of setting up a reparations program, nothing has happened to date. All the responsibility is being put by the Ugandan government on the ICC based on the conviction, recent conviction of Dominic Ongwen, one of the members of the LRA, by the ICC. The Ugandan government has really not done much to redress harm derived from the conflict. So that's one challenge. Another major challenge that we see is the high levels of impunity that still prevail for gross violations of human rights and humanitarian law. And impunity is very high, in particular when it relates to state officials as the perpetrators of these crimes. And this is often because of the application of amnesties, the lack of political will to investigate, and the reluctance of really the political and the military elites to give up their power and their influence in society. Again, an example of this could be Uganda, where only a handful of members of the Lord Resistance Army have been prosecuted today, but no state official has been investigated or sanctioned in relation to abuses committed during the internal conflict. Also in Guatemala, we have had some landmark judgments, very, very emblematic decisions, but this has been achieved mainly because of the pressure from victims and the international community. And even in those cases where we have emblematic judgments, we also see that that has been followed by threats and attacks against the judges and prosecutors who were working on those cases. Another lesson learned, I guess, is the tension between achieving peace and reconciliation in society coming out of conflict and honoring the rights of victims to reparations. And this tension exists, but we also see some good practices and experiences that tell us that it's actually possible to promote peace with, for example, incentives for combatants to reintegrate themselves in society without really compromising the rights of victims to truth, justice, and reparations. An additional lesson is perhaps the role of non-state actors in ensuring reparations and the fact that this is a field that has been really unexplored, and it's something that the guidelines address. And equally, more attention also is being put nowadays on alternative ways to ensure reparations from a financial perspective. For example, through the confiscation and repurposing of assets owned by those who are responsible for violations. I think this debate is slowly coming to light now in the context of the war in Ukraine and the assets of Russian oligarchs that are being seized all around the world, but it's actually an older debate that we've been trying to scream, this is important and we have to look at this. Then we also have examples of reparations that have been granted and ordered by courts, but where the reparations programs have had difficulties to start, either because of a lack of technical expertise, lack of funding, or political will. And an example of this takes place in Chad, where reparations were ordered more than 6 years ago by a special court in Senegal during the conviction of Hissène Habré. And in that decision, the court trusted actually the African Union with creating a fund that could provide reparations to victims. But again, this was 6 years ago and the fund is not operational today. And also victims are really dying because they are elderly now with no reparations. So for example, this is being addressed by the guidelines in principles 11 to 15, where we give some considerations that perhaps stakeholders want to keep in mind to develop reparation programs, such as, for example, the need for simplicity, transparency, criteria for eligibility, etc. An additional lesson learned over the last 15 years is really the need for certain groups to receive reparations based on the specific types of harm that they have suffered. In the past, the gender dimension, for example, of harm has been often ignored, and those of us who are practitioners often see that, for example, the harm suffered by the LGBT community during conflict has been often quite ignored. But we also have other categories of victims in this group, such as victims of conflict-related sexual violence, victims who belong to indigenous communities, child soldiers, children born out of rape, and other groups. And so more attention is increasingly being paid on specific forms in which documentation and reparations have to take place to really redress those harms. And finally, I would say another challenge is basically that very often we don't see enough attention on how to tackle the structural causes that created conflict and generated conflict to avoid it, to avoid the repetition of violence in the future. This is on challenges, but there are some positive lessons as well that we've learned from experience. And I think one, or the most important one for me, is the high rate of success in the implementation of reparations when victims participate meaningfully, and also civil society supporting them. When they have agency, they organize themselves and they demand reparations to take place in a certain way. And from this important lesson comes another one that I think Peter mentioned in the last panel, and it's the need for the international community and the donor community to support victims. Because when we say that victims participate, they need to have the tools to be able to participate. I mean, victims often have the will, but they don't have the means. And transitional justice processes last decades. And what we see is that often donors pick and choose. Now this country is has all the attention of the donors. 5 years later is another country. And this is very harmful to some extent. Victims get support for 5 years and then that's it. And it doesn't really work like that. So I think a lesson learned is the need for long-term support for these processes and for the involvement of victims in these processes. And so the Belfast Guidelines are really being launched today to try to respond to some of these challenges and good practices in the field. Thanks, Ruben.
Thank you. And let's now also hear from Clara.
Okay, thank you so much, Ruben. Good afternoon to everyone. It's a pleasure for me to be here. I wish I could be in person, and I'm so happy to be surrounded by such an amazing audience, many people who I highly respect because of the work they've been doing to advance the fulfillment of the right to reparation for victims. I just would like to start saying some of the things that actually Sandra said. I think we in a way, yeah, sorry to have to repeat some of these things, but maybe repeating might mean that we will stick to them. The first one is something that we saw during our field work in the project, is that there are common problems. And one of the key problems is, of course, the massive implementation gap that reparations face. So many states around the world are really saying, yes, we believe in the right to reparation and we want to move towards reparations. Then they engage in the setting up of a framework to provide reparations, but then they do very little to actually provide reparations to victims in general, and let alone those vulnerable groups of victims, including survivors of conflict-related sexual violence, that very is in just small opportunities when they get to see the right to reparation actually happening. So we wanted to respond to that by going to those places where different actors would be able to tell us what was working and what was not working. And I think part of the work of this project, and look, I'm sure you've said this already, has been precisely to listen, to learn to listen, and to try to put together some key lessons learned, good and bad, about how we can respond to the implementation gap. And I think this is something that the basic principles did not do, because the basic principles, as much as I use them on my daily work, are a set of key principles, the basic principles that try to flesh out in one way or another what that right to reparation actually means. but they did not deal with the question about how do we go translating this right into an actual right for victims around the world, no? So what we've seen since 2005 and before, for those that have been working on reparations even earlier than that, is that we have had problems seeing how. I think this is the key question that we wanted to respond to. How do we go about dealing with the implementation gap? And I think a major contribution of the guidelines is to be there, trying to respond to the how. How by, of course, doing what Ruben clearly said, bringing the voices of different actors in the global south, facing this massive challenge on a daily basis. And something we saw in different countries is not always that it's so easy to say is lack of political will. There is far more than that when it comes down to reparations, no? We saw many people working for state institutions with all the will to actually execute reparations, but lacking different means to do that, or without a clear understanding of how to go through that roadmap, no? So I think what these guidelines are doing, and I really applaud the guidelines in relation to that, is trying to respond to the how. And as a contribution that comes from the Global South, I also think that a key contribution they made is that they try to establish a space for transdisciplinary dialogue. I agree with Ruben, norms sometimes can be difficult in these areas, but also sometimes can be an asset. But what I love about the guidelines is that there was an effort here to invite different disciplines, different actors to speak about reparations, no? To try to think about how do we go about implementing them, because reparation is not only a legal issue. It is a right, yes, but it's a right that to be materialized requires of the work of multi-stakeholders, yes, and I think that was something that we aim to do. Something else that I think is important is that we took context into account. So I think that while the guidelines try to still practice a best practice, or not best practice, but a lessons learned, we did try to be sensitive as much as we could to context. And I think that's also key. But in terms of content, I think that they take us a step ahead, or quite a few steps ahead, in relation to where conversations are at the moment, trying to, you can see it, either providing some first views on these issues, bringing together some views that different people, sectors, etc., have expressed about these issues, and actually pointing on the direction that we need to continue to look at in the future to continue to respond to that question about how do we go about making reparations possible through domestic reparation programs. And here, I think various things happen. So we not only try to talk about the how, I think there was also a key question to answer, and was for whom, no? And here, I think that another major contribution is that we moved from for example, from the basic principles that, as I said, I really like, that are, gender neutral. They don't say anything whatsoever about these issues, to a guidelines, or a set of guidelines, 15 of them, that really take into account vulnerable populations. There are so many references with key lessons learned in them that talk about child soldiers, children born of war, conflict-related sexual violence, the elderly, the disabled. And I think this is, again, key to advance discussion. So the whom is also addressed. Of course, recognizing that victims in general have a right to reparation. They also talk about what to do and what not to do, by reminding key principles, the principle of do no harm, but also what needs to be done, and is putting survivors at the center. I cannot agree more with Sandra when she says that if there is a lesson that we've learned, is that reparations are incredibly effective, impactful, and successful when victims are at the center, when they are truly involved in creating reparations, as we would say at the Global Survivors Fund, co-creating reparations, where their views are taken into account, where they take leadership as well, without omitting the fact that at the end of the day, the duty barriers are others, no? The state, the perpetrators, etc. But still, victims can have this reparatory experience that is itself, is part of the healing, but is at the same time incredibly life-changing. No, we've seen it with the way they have literally transformed the field of action in relation to reparation when they've been involved in it, giving it shape. But the guidelines also talk about topics that often we don't think that much about because we see it very legalistically, and are issues, for example, related to funding, repurposing of assets, etc. No, let's start linking these to broader issues where we need other disciplines to step in to let us think, how can we make this possible? So that this argument that always comes up once and again, that reparations are not affordable, is actually dealt with, addressed. No, so I love that the guidelines say something about that. I love that the guidelines talk about interim reparations. This is a point that, for example, we included also in the Secretary General's guidance note on reparations for conflict-related sexual violence, that victims, survivors of conflict-related sexual violence are entitled to interim urgent reparation measures. And I think this comes up here again. We've seen already practice, from Mali to South Africa to East Timor to the Gambia, about how transitional justice mechanisms that are not necessarily domestic reparation programs are beginning to realize that we need to act while domestic reparation programs are in place. And by recognizing that need and beginning to think how we link humanitarian assistance, for example, that steps in many times before domestic reparation programs kick in, by thinking how can we use inspiration there to actually build reparation in an urgent manner to respond to the most urgent needs of victims. I think that, again, this is an area that requires further reflection, but I think the guidelines are definitely making an important contribution there. The amendments, the making amendments, I think this point is absolutely key to, again, fill a massive gap in the law and in political discourse on how to deal with these issues. Another key area for me is the whole issue about complementarity. No, and this is, I think, in terms of, and I would love to have a space where we could all think about what is going to be the field of reparation, the landscape of reparation within the next 20, 30 years. What are the massive issues we are going to face? What do we need to be ready for that? I think this issue of complementarity between remedies, judicial, domestic reparation programs, etc., are going to be more and more there. That's part of what we need also to be thinking about. But let me also say, of course, that by addressing non-state actors, the role of civil society, etc., we go a long way to recognizing that for reparations to be possible, you don't only need the duty bearer, the state or the perpetrator, but you need other actors to actually be able to take that vision, that dream, that view of survivors to reality with them, no? So what is the role that different actors in society have to play to deliver on reparations? I think this is a question that the project itself, but also the guidelines, try to address. And finally, I think that this type of guidelines will become incredibly useful in many places around the world that are currently facing the question of how to deal with reparations. I, on my daily work, am facing this question. So in the Democratic Republic of Congo, where there is currently a full, negotiation of what would be a domestic reparation program and a transitional justice framework, this question comes once and again. I was just looking at the latest draft of the potential law on the issue, and I am going to send the guidelines because I think they can be incredibly helpful. In Ukraine, again, we are having these big questions. In the Gambia, with, again, putting together a full law on this issue. And I can continue country after country, showing the new opportunities we have today that we did not have 20 years down the line. And this is because, although slowly, the right to reparation has gained momentum and opportunity. And when there is momentum and opportunity is the moment to translate really the theory into the practice. And my invitation to all the academics here and to, of course, the practitioners, I know we are working on this on a daily basis, but those that have the academic hat is we definitely have a lot to contribute, thinking about how to bring other disciplines together to consider these massive issues of implementation. So, and I just would like to conclude by saying that, look, I know you wouldn't like me to say this, but I am going to say it. You have led this project from beginning to end, trying to accommodate different people, different views, to be responsive, to be inclusive, with great leadership. And I think this work has been possible, as well as all the publications that came through the work, thanks to your leadership. Of course, I'm not acknowledging the other great work that the rest of the people on the team did. Amazing people, really a pleasure to work with everyone. But you were absolutely at the heart of this work. And I do hope that these guidelines are not the end. As I said, these guidelines show a beginning where we need definitely to take action. Thank you.
Gracias, Clara. And I know you have prepared remarks, and I was about to ask you certain questions, but I will do that after this.
Okay. Thank you, and thank you, Clara, for those kind words. The guidelines themselves, I think, what they're trying to get to is how to get reparations back on the agenda. You know, in Northern Ireland and other places, and even, Ruben was saying earlier, we've got an international criminal court and not a court for reparations. We think about Ukraine, and everybody's talking about how do we punish Putin. We don't, how do we sort of take away their assets? We're all about the punitive and not about trying to restore or repair. How do we help those victims? How do we try to rebuild? And again, people were asking me earlier, and also Ruben, you were talking about the nature of conflicts. We have talked about post-conflict here, but you'll see from the guidelines we're also talking like interim reparations. We're talking about making amends. How people like the US and the UK, when it bombs people in the Middle East, it pays them compensation. How that doesn't extinguish the right to reparations. I think these are some contributions that these guidelines make. We want to put reparations back on the agenda. We want it to be something that is seen as not something that's completely complex and you need 400 lawyers to work it out, because that's going to cost you more than the reparations program. But you want to be able to have a conversation. You want to have a conversation not just with victims, but those responsible, to say, how do you take ownership of your past violations and try to make amends and make good in that? I think reparations are an important contribution to dealing with the past. And that's why in these guidelines, we don't just talk about the state, we talk about armed groups. We also about other responsible actors. Ruben mentioned financial institutions that were responsible for contributing to the violations that rose in Tunisia. But it also applies to others, like peacekeepers, to religious orders, to a whole range of actors that are complicit in violations and have obligations towards victims. It's not just the state. We do think that the state is primarily responsible because it has the human rights obligations to do it, even if it isn't necessarily directly responsible for those violations. At the end of the day, the buck has to stop with it. It's there to protect its citizens, it's there to serve us, and when it comes to reparations, where it may not commit violations, where they're committed by private actors, whether it's paramilitary groups or corporate multinational corporations, it is still there to ensure the rule of law, that victims, where there is a violations, have a right to a remedy. And that's what's key in the guidelines, that I think too often we're pushed down the avenue of justice, that having an international criminal court or bringing people to court will actually solve things for victims. Criminal courts are a narrowing exercise in the sense that it depends on sufficient evidence to have a reasonable prospect for conviction, and that's often rare. Reparations are focused on victims. We do say in the guidelines that there are victim-centered measures, but I want to go beyond that. I think reparations are a way for perpetrators and responsible actors to sort of normalize themselves in society, that they're no longer the boogeymen, the bad people. They're people who have done bad things in the past, and they don't want to be defined always by them. They recognize that things were wrong. Even though they justified them, they were politically and ideologically motivated to plant bombs in cities and to shoot people. But now, in peace, they recognise that maybe that wasn't necessary, that actually this harmed people. And that's what Kieran was talking about earlier, about the need to humanise both the perpetrators and the victims. They take ownership of the past. And so these guidelines, we want to contribute to that. We want to sort of dispel the legalese around reparations, that this is something which is practical. And at the very back in Principle 15, a bit like the Geneva Conventions, not saying I'm trying to, I'm not Jean Piquet, but what I'm trying to say is I try to make a mini guide that if somebody's going to try to draft regulations or reparations law, Principle 15 is there for you, because it's got all the key things you need to do in order to ensure that your regulations themselves are in line with sort of best practice. And I think Ruben's right, we don't want to sort of create norms that rigidly apply in copy and paste situations. I think reparations are a journey. Paul talked very well about the struggle that it is to get reparations done. But it's a journey of trying to deal with the past, and reparations programs don't get it right the first time. They evolve. We see this in Northern Ireland. We got the door open for seriously injured victims, but what about for the bereaved? What about suffered torture, sexual violence? When are they going to get their day to be acknowledged and repaired? And so for these guidelines, I want us to have this conversation about reparations. Here in Northern Ireland, in Yemen, in Ukraine, it hasn't just something which is limited to those which capture attention. Clara and others have talked about the time-limited nature of a lot of these things, that this isn't done in a year or 5 years. Reparations take decades, especially when we're dealing with large conflicts. For instance, in Colombia, which I mentioned earlier, you've got 9 million victims, and if all those victims at the current timeline are going to get reparations, it's going to take 75 years. There's some political will to deal with the past, but then, as Clara says, there needs to be money, there needs to be support mobilised in order to deliver that. So I think I'll leave that there. And then, Ruben, you're going to do a couple of questions?
No, I think you anticipated some of the questions I would have asked, so you will be spared from many of them. I was just going to add, and I'm sure there are questions, and I don't know how much time we have.
Yeah, maybe open up, yeah.
I think Peter mentioned earlier that he's helping out in the racial justice and reparations questions in the United States. And I think it's also important to think about that in terms of where the Belfast guidelines are useful, that they're useful in the global north, where you have countries that perhaps finally are dealing with legacies of injustice and inequality that were masked by development, by relative prosperity of many, but not all. ICTJ has been asked, for example, by the Reparations Task Force in California to deal with a very specific question on reparations, which is whether California should provide reparations only to descendants of slaves or to African Americans who suffered racial injustice. And that's, of course, a question that you can discuss endlessly, but then when you have to implement reparations, you can't discuss it endlessly. You have to then take measures and decide and make very hard decisions. And I think it's important to remember that not just in the context of the global north, but especially in the context of the global south. Clara and I did work in the Central African Republic in a ICC context. And the difficulty there, of course, as those who take the country, the Central African Republic, seriously, is that it is not a state. It's a creation of French colonization. And then it operates as if it were a state, but really it's mining companies that operate in the country, and now also mercenaries. So how do you respond to that situation and talk about reparations? So it's important to understand different contexts, and I think that's the value of guidelines that emerge from those different contexts, and also take from this context, literally from here, and imagine what legacies of colonization that are transformed into sectarian conflicts look like. Because that then becomes another question in many of the global south countries, where you don't have the conventional notions anymore of conflict, where you have sectarian identity as the basis of conflict. And so I think that's an important point that the guidelines can address. But if there are questions, then you can ask them now. How do we know if there are questions online?
Danielle's going to.
Yeah, thank you so much for putting together the guidelines and also for the critical comments and support. I would like to go back to something that Alejandra said about the importance of, or the impact of meaningful victim participation on reparations and the importance of the support of the international community. And I was wondering if you could maybe elaborate a bit more on how that support should look like, apart from being more sustainable and more long-term and moving away from donor trends, which we have known for a long time that they are very harmful, but how can we transform this international community support into something more meaningful, avoiding all the traps of sustaining also problematic patronizing relations between, for example, NGOs and victim groups? How can we really create a meaningful international support that is really empowering for victims?
And there's no online questions yet? Okay, so Alexandra?
Thank you. Thanks so much for the question. And I think it's an extremely important point to explore further, because sometimes we use these terms, victim-centered approach, and we use it so much that at the end we don't really know what it means anymore. And you are absolutely right that one important aspect is to ensure the support. But why is support important and how it should happen? Some of the experiences that we see in the field is that sometimes even civil society supporting victims can be a little bit partial as well. And so, for example, we work with victims in Cambodia where their concept and knowledge of reparations is very limited because this is what they were told that they could get from courts and from programs. You know, their view is narrow because of their understanding of the concept as it was also explained by those working with them often. So something that is, in my view, quite important is to really create solidarity networks among survivors and victims, to empower them to be really actors of the whole process in defining what reparations mean for them. And Ruben and others mentioned, you know, different contexts, different meanings of what justice is for different victims. This can only be explored really by survivors themselves. And so, but of course, sometimes, not sometimes, oftentimes, or almost in every context, we also see that victims and survivors are still living in exclusion. And this is really common across context, I think, that victims are still not having access to basic needs. So if that's the case, then how can they organize themselves? How can they participate? How can they form solidarity networks? And how can they strengthen the movement to really have an impact in the discussion at the national level? So I think this is a debate that, as you very well say, does not depend only on financial support, although that's quite important, but also it depends on how we all interact with victims and what we expect of victims and how we promote that participation by victims. And I think it's a learning process. I think that a lot of mistakes have been done in the past, and you know, the Belfast principles are also, I was going to say, it's just a tool, but I'm sure that there will be other documents in the future, because the field is very complex. There is a lot of work to do. And this is not the end. This is just a reflection on what we see so far.
The mic is coming.
Just to follow on Alexandra's point, we have a saying here, there's no need to reinvent the wheel. And we've talked about best practice and other things, and there are certainly examples there. But as we have learned in Northern Ireland and many other places have learned, this is a transitional process as well. And it would be ideal to get it right at the outset. But Ruben, as you have said, the context is so important. And therefore, not every incident of conflict around the world will apply to another situation and the actors within that situation. As part of our work over the years, I was privileged to be invited to the European Day for Victims of Terrorism, and I know that word and that language can be challenging for some. But Juncker, the then president, had appointed Wilke, who was former, I think, Belgian Interior Minister, but she was a barrister, a human rights barrister, to look at the whole reparation situation. And they did a presentation at which I was present, and Peter Heathwood made a presentation at that too. And it was all about debunking the legal aspect of it, as your guide's seeking to do, and to try and ensure that the reparations were dealt with in a timely, empathetic manner and addressed the need, which you have said is the most important thing. Needs can be identified. Want and wishes and all of those things are something you can work on, but there's, you know, this guy needs his artificial legs sorted. That's pretty evident, if you know what I mean. So there are things that can be short-term, identified short-term. They're not only transformational for society, they're transformational for that individual, for their family, and in the making of peace and enabling that society to move towards the ultimate objective of a shared future. So any dummy's guide to how to get it done is hugely appreciated. So thank you, Luke.
Thanks, Mark. So far the guidelines have we've got the little green book for people in Northern Ireland will have that a certain connotation, and the dummy's guide. So I'm glad to see it's being taken on board and given a life of its own. I think that there was a meeting a few months ago, so it was about broadening out the EU directive to help Ukrainian victims, and how the EU directive could be helped to those who were coming across in the rest of the EU, could be recognised for the directive based on aggression. And something which was raised with them was that this is incredibly problematic, because why aren't you doing it for the Afghan victims or the victims coming in from Ethiopia? It's a very sort of privileged, and it's a hierarchy of victims again. I think a lot of things which play through in the guidelines is Northern Ireland isn't all that different from everywhere else. It's a human problem we're dealing with here. And we were even talking about at lunchtime that when it comes to people who commit these violations, there is an aspect of trying to stick the moral high ground, that we were there to protect the community, we were there to serve, we were there to carry out some sort of function, and there's no way we did those sort of violations, and we just need to stick to that story. So it's about the denial and silence that also stymies victims and reparations claims. And I think what we're trying to do is to try to get people to step back from their trenches maybe a bit around dealing with the past and confronting that legacy, because we know in this country that we've had hundreds of years of refusing to deal with the past. Whether it's it's 100 years since the pogroms that were carried out in Belfast, or the consequences of our civil war, those have an intergenerational effect, and we know this. And I think with the guidelines we are focused, because the project was on in post-conflict societies. But what about those countries, as Ruben was saying, about dealing with colonialism? Last month I was engaging with the Belgian Commission on its colonial past in the Congo, where you effectively had genocide committed, where 10 million people in the Congo were just wiped out. But what about the British consequences, or the Dutch atrocities carried out in Indonesia, at a point of decolonization, where we gave, like as privileged as the Western states were in taking over these countries, we gave them statehood, we gave them railroads, and then just said wave goodbye. And we didn't think about actually all the victims that were left behind, the millions of people who are left to live with the consequences of that ethnic division and exploitation of resources. And then for those people who were, like with the Mau Mau, left maimed and tortured, or family members killed, nothing was done to properly redress that. Instead, we created a narrative, Western countries, that we do developments, we do prosecutions of some of the worst atrocities in the world, like in the ICC, which mainly happen, which mainly focuses on in Africa, and we haven't properly dealt with our own responsibility in setting the frame for those conflicts to happen in decades to come. And so this Belfast Guidelines are focusing on recent conflicts, perhaps conflicts like in Colombia, which are still ongoing, or Ukraine. But I think it's also encouraging to think about how do we recognize victims that aren't just those in the media at the time. And it was talked about earlier about, Ruben, you said about, with climate change as well. How do we think about, these are things that we've created. How do we take responsibility for that in a broader sense and to repair it? Which is maybe just gone a bit beyond, but maybe to think about looking forward.
Well, Clara, do you have anything you want to add?
Well, no, to see where this is gonna go. That's my question for Luke, and I think it's very important to take a stock of some of the reflections we heard through the process of the guidelines about how to, for example, now create spaces with survivors, with victims, with civil society organizations and other actors to see how the guidelines can be improved, how other key tools can be developed in the north and in the south, different places. I think that's to me a question, what's next? I think this is a project, by the way, that opens great opportunities, really, truly, for survivors and for victims in general, no? So what's next in terms of the academic committed research agenda? And yeah, this is like an open question. I know I don't expect you, Luke, to tell me that you're going to put another project in the next month or so. No. But I think we all need to think about how different projects that different academics will engage in can continue to advance these conversations, precisely thinking about victims. And maybe just to add something on the survivor-centered approach, I think that nowadays, the common words that you listen, like these buzzy words everywhere is you need to have a survivor-centered approach, you need to have a survivor-centered approach. But very few people know what that means. And many people actually want to limit that to some kind of participation of victims that is mainly about giving them information, but not listening to them and engaging them in these processes. So I really think that there is a massive gap within all spaces, from the action to the academic literature, on fleshing out what it means and how that's actually possible, and countering the many arguments that are out there trying to remove that, because many see that as an obstacle, since don't work effectively, fastly. There are all of these arguments that we need to counter. And on that, I just would like to just to make a bit of propaganda here, but we are the Global Survivors Fund is co-sponsoring an UNGA side event in New York on the 22nd of September, particularly on co-creation and survivors' participation with various states, the United States, Canada, Ukraine, France, etc., precisely to bring different actors together to talk about the issue. Because again, if we truly believe that reparations are possible, if we all work together, we need to be able to start having these conversations and reflections together. So for those of you that are interested in following up on this, I will be sharing information about the event that you will be able to join online.
And any more questions from the room? If not, then I'll ask you to make the closing.
Yes, okay, thank you everybody. I'm going to do a very, very brief closing because it's after 4 o'clock and everybody sort of fades in. Tim, is it possible to get my final couple of slides up? Okay, and maybe to click on to the next one. So we first talked about reparations in this country, thank you, about 2014. We brought up Judge Clara Sandoval over here to have a conference on reparations. It was after Kieran's project on amnesties and public prosecution interests. And what we wanted to do was sort of broaden the conversation on reparations. Since then, we've got to this stage, we've done a project, we've got the guidelines, and all these things are going to come out. And I think a lot has progressed. What I was sort of going to do is just to tie up that Sadly, actually a few weeks ago, Judge Cansado Trinidad actually died. He was one of the keynote speakers. He was a keynote speaker at our conference in 2014. And he always kept in contact to find out what was happening. He pushed for one of the major reparations decisions that came in earlier this year, the DRC v Uganda case. It's a massive case of $320 million being paid out for one country invading another. But in his talk here in Belfast, this was before, long before the injured scheme was put in place, or these other cases were heard internationally, he made this statement. He said that, human justice is not the time of the human being, that often it takes decades, it takes generations, and that from his experience working in Latin America, from victims of disappearances of the military juntas, the massacres in Guatemala and Colombia, he knew the struggle that victims faced, that for many victims, they will never see those responsible held to account. And for him, the whole point of international law and his quite substantial contribution was to ensure that any victim around the world had a right to reparations, and that they had international standing to bring those claims to international bodies, to claim their basic human rights, that it wasn't just states that held these things up, that everybody who was born had a right to pursue and to seek and to receive justice, and particularly in reparations. And he strongly developed the field that when we talk about the 2005 UN Basic Principles, his jurisprudence at the Inter-America Court and his quite long separate opinions were key at sort of framing that he saw beyond what was happening now to see in the future, but also to learn from the past. And I think there's a lot to take away from that, because he was a man in the desert calling out for justice when nobody else was listening. So I think it's poignant that we finish in him and we remember what he's given, and how he continues to inspire, that we still struggle for redress, that this is not the end of our debate on reparations. This is just the end of one chapter and hopefully the beginning of a new. So thank you to everybody for coming along today and for still hanging about. I really appreciate it. All our guidelines and handbooks are online and they've been translated into the 5 working languages of the UN. If there's anything further, do DM me on Twitter or drop me an email. So thank you very much for your attention. And there's coffee still left.
Congratulations. For years.